Stop. Open your calendar right now. Look at the next 7 days. Do you see a meeting from HR? Vague title. No agenda. 15 minutes. Maybe Friday afternoon. Don't accept it. Not yet. I've spent months reviewing EOC enforcement data, employment case files, and interviews with HR professionals, and the pattern is consistent. Today, I'm breaking down the 3 signals hidden in a termination calendar invite, with the numbers and case law to back everyone. Here's the scale of what's at stake. The EOC received 88,531 discrimination charges in fiscal year 2024 alone, a 9% increase over the year before. Retaliation has been the most common claim for 17 consecutive years. These aren't rare cases. This is the new normal. The second you walk into that meeting, 3 things go on the chopping block. Your paycheck, your family's health insurance, and every dollar of 401k, matching from that day forward. 1 meeting, 3 losses. Stick around for sign 3. It's the cleanest tell of all. Quick note, this is education, not legal advice. Before any termination meeting, consult a licensed employment attorney in your state. Most offer free initial consultations. Picture this. You're at your desk, coffee getting cold. A calendar invite slides in. Quick sync with HR. You accept and forget about it. Here's what already happened on the other side of the building. Your manager and HR met privately, often more than once. Legal pulled your personnel file. They modeled severance scenarios. They drafted a separation agreement with the release of claims. A contract that once signed typically waives your right to sue. In many companies, recruiting was screening replacements weeks ago. Then HR opens the calendar, picks a time, and sends the invite. You're not walking into a meeting. You're walking into a delivery. 3 signs to recognize it. Sign 1, the title is empty. Quick sync. Touch base, check-in. 15-minute connect. Real meetings have real names. Q3 budget review, marketing handoff. Real work tells you the topic. Nobody hides the agenda for routine business. A vague title isn't lazy. It's careful. HR teams are coached on documentation hygiene. Under the federal rules of civil procedure, almost any internal company communication is potentially discoverable in litigation, including calendar invites, Slack messages, and emails. If they label the meeting performance discussion or pre-termination review, they've just generated evidence your attorney would subpoena. So they sanitize the title. The vaguer it reads, the more deliberate the choice. This isn't theory. In wrongful termination cases that reach discovery, vague calendar invites get pulled, screenshotted, and presented to juries. The U.S. Supreme Court's framework in McDonnell Douglas v. Green, a 1973 decision still controlling today, governs how courts evaluate whether the employer's stated reason for firing was real or pretext. The paper trail decides it. Sign 2, check who else is on that invite. Just you and HR? That's a flag. You, HR, and your manager? Bigger flag. You, HR, your manager, and a name you don't recognize. Worst combination. That unfamiliar attendee is almost always a witness. Companies bring witnesses to terminations to corroborate their version if you later file an EEOC charge or a lawsuit. Sometimes it's a second HR rep. Sometimes it's in-house counsel listed as HR business partner or people operations. Sometimes it's IT, and it is in that room for one purpose: to revoke your access, email, Slack, VPN, badge, the moment you walk out. Flip it. HR meeting with no manager present, different signal, same problem. It usually means HR is investigating your manager, or what they are about to say involves your manager. There is no such thing as a routine HR catch-up. HR teams typically operate at a ratio of 1 HR person per 100 employees. They don't have spare time to chat. Here's something most people don't realize. The friendliest HR rep in the room is often the one to watch most carefully. HR is trained in interview technique. Open-ended questions, sympathetic tone, long pauses, designed to make you fill the silence with admissions. Anything you say in that meeting can be summarized in a contemporaneous memo that lives permanently in your personnel file. Warmth in that room isn't always friendship. Often it's technique. Sign 3, the one nobody talks about. Look at when the meeting is scheduled. Late Friday afternoon, end of day. Last hour before close of business. A conference room nobody normally books instead of your manager's office. That's not coincidence, that's choreography. End of day meetings exist for one practical reason. The company wants you out of the building quickly and quietly. They don't want a scene, they don't want you walking back to your desk to vent, and they don't want you live slacking the news. Friday afternoon is the favorite slot. It buys the company a full weekend. By Monday morning, your team has been told something neutral, your work has been redistributed, and your accounts have been disabled. The conference room matters too. Normal one-on-ones happen at your manager's desk. A booked conference room means privacy, neutral ground, a closing door. and often a second exit, so a witness or IT rep can step out and trigger your access shutdown while you're still mid-sentence. You know the room, the one with no window, the chair that squeaks, the one nobody books unless something serious is happening. That room. If HR books that room, that's the room. One sign alone means nothing. Vague title could be lazy scheduling. Bad time slot could be a packed calendar. But all three together, vague title, HR plus manager plus a stranger, end of day in a closed conference room. That's the pattern. It shows up consistently in PIP delivery, layoffs, forced demotions, and pretextual investigations designed to push someone out without severance. Remember the stakes. Industry surveys put typical US severance at 1 to 2 weeks of pay per year of service. Roughly 57% of employers offer 1 week, about 24% offer 2. Modest, and almost always negotiable. Lose health coverage, 401k, matching, unvested stock, and an earned but unpaid bonus on top of that, and a single meeting can erase well over 6 figures of future security. 4 moves the moment that invite lands. In order. 1. Don't accept blindly. Reply in writing. Happy to meet. Could you share the agenda so I can prepare? Watch the response. A real agenda? You may be wrong, and that's a relief. We'll discuss in the meeting. You've documented the evasion. Save that email thread. 2. Call an employment attorney before the meeting. Most offer free 15 to 30-minute consultations. State protections vary enormously. At will is the default in 49 states, but exceptions like implied contract, public policy, and the covenant of good faith are real and litigable. 3. Do not start forwarding company emails or documents to your personal account. This advice circulates online, but it can support a for-cause termination, which often eliminates severance entirely, and in some states raises separate legal exposure. Let your attorney guide what can be preserved and how. 4. Document everything legally, at home. Pen and paper, dates, times, exact words, who was present, what was said in every performance conversation. Never on company equipment or Wi-Fi. A handwritten timeline reconstructed from your own memory at your kitchen table is fully yours and admissible. And here's the part that surprises people most. When they slide a separation agreement across the table, don't sign it. Not that day, not that week. Companies push for fast signatures. They know the longer you wait, the more likely you are to call counsel. They'll say, this offer expires Friday. It's standard. This is the best we can do. Often, none of that is accurate. Under the Older Workers Benefit Protection Act, employees 40 and over must be given at least 21 days to review a severance agreement that waives age discrimination claims plus 7 days after signing to revoke. For group layoffs, that review period extends to 45 days. Many companies would not volunteer those numbers. And severance is negotiable. The EEOC recovered roughly $700 million for nearly 21,000 workers in fiscal year 2024 alone. Companies budget for legal exposure. They'd often rather pay more than fight. But that leverage exists only if you don't sign first. The pen they hand you in that meeting is the most expensive pen you'll ever pick up. HR is not your enemy. HR is also not your friend. They are the company's risk management function. The calendar is their first tool. The people who survive this with their rights intact are the ones who learn to read the invite before they accept it. Drop a comment. Has HR ever scheduled one of these on your calendar? What was the title? Patterns from this thread have helped people spot tactics they'd have walked right into. If you've ever been blindsided, send this to one person at work who needs to see it before Friday hits. One last thing. There's a 4th sign I didn't include in this video. It happens after you've already walked into the meeting. It's a single sentence HR is trained to ask within the first 2 minutes, designed to get you to admit you saw the firing coming. Most people answer it before they realize what they've said, and it can cost them their wrongful termination claim. I'll break that one down next week. Subscribe so you don't miss it. Until then, open your calendar. Look at the next 14 days. Anything vague, late in the day, too many attendees, you already know what to do. See you next week.